Learning Objective 5 in Module C deals with the Securities Act of 1934. And the Securities Act of 1934 handles or regulates the daily trading of securities, and as part of that requires periodic reporting and financial statements to be filed with the Securities and Exchange Commission. And so looking back, when we talked about the 1933 Act, that again is dealing with IPOs or initial issuance. And so these are the more day-to-day types of regulations related to securities. And the 1934 Act, as it relates to auditor liability, deals with an auditor's liability for gross negligence and fraud. And so the important part or provision from the 1934 Act related to this is Rule 10B, 10B5 of the Securities Act of 1934, where it sets forth what investors must show if they're going to sue an account related to issuance of securities. And because it's dealing with gross negligence and fraud, you guys already know what they need to prove. It's misre and mystery. So it's material misrepresentation or omission, scienter or recklessness, depending on what level of negligence they're bringing the suit, and reliance and injury. So the same things that we've already learned. And one of the important parts of this is that they have to prove that the loss was caused by reliance on the financial statements. So again, the burden of proof has shifted to the investor rather than being on the auditor. So proving that not only those things existed, but that reliance is a very important part of the 1934 Act in terms of limiting auditor liability. So what defenses are available? Good faith, particularly if they're bringing a suit based on fraud. Similarly, knowledge. So if they're bringing a suit based on fraud, part of it is knowledge of the falsity as well as intent. So you always say that you were not aware. Ernst & Ernst v. Hochfelder relieved auditors of liability for ordinary negligence under the 1934 Act, but did expand an auditor's liability to be not just for fraud, but also for reckless behavior in the absence of scienter. So let's apply this. Under the provisions of Section 10B, Rule 10B5 of the Securities Act of 1934, which of the following activities must be proven by a stock purchaser in a suit against a CPA? And so we see intentional conduct, negligence, and materiality. So if it just says negligence, you shouldn't infer that they mean gross negligence. So this is suggesting ordinary negligence by the CPA. So that's not going to be a good answer. Materiality is always a good answer. And then certainly intentional conduct, if they're bringing a suit for fraud, would be an important thing that they would have to prove. So the best answer here is G, which is 3 and or 1, which is basically saying definitely materiality, perhaps intentional conduct, but it does not have to be intentional conduct if the suit is brought based on recklessness or gross negligence. Okay, this is one of my favorite multiple choice problems of all time. And I use this on exams. You will absolutely see this on your exam. And the reason why I like it so much is because I can change just a few things and I can make each of these answers correct. So let's now apply what we know about the 1933 Act and the 1934 Act to this specific set of circumstances. So it says, Ocean and Associate CPAs audited the financial statements of Drain Corporation. As a result of Ocean's negligence in conducting the audit, the financial statements included material misstatements. Ocean was unaware of this fact. The financial statements in Ocean's unqualified opinion were included in a registration statement and prospectus for an original public offering of stock by Drain. Sharp purchased shares in the offering. Sharp received a copy of the prospectus prior to the purchase but did not read it. The shares declined in value as a result of the misstatements in Drain's financial statements becoming known. Under which of the following acts is Sharp most likely to prevail in a lawsuit against Ocean? And so, for the purposes of this problem, if everything that the plaintiff needs to prove is present, you should choose or select yes as the appropriate answer. So let's go through what we know about uh, the specific situation and then look at the Securities Act of 1933 and 34. So first, we know from the buildup that they were material misstatements. So that first part, material misstatement or omission, is present. However, we also know that they were unaware of this fact, so that we know that any kind of suit based on fraud is not going to be good because it's going to be hard to prove knowledge and intent if they were unaware of the misstatements. Another thing that we know is that the person that purchased the stock and who were injured did not read the audited financial statements. If they didn't read the audited financial statements, it's going to be difficult to assert that you relied on the financial statements. The shares declined in value, so there was some kind of injury, so that is present. And so right now, what do we have? We have material and injury. We don't have scienter. We don't have recklessness. And it looks like we also don't have reliance. So we don't have two of the important things in terms of proving fraud or gross negligence. But another consideration when we're thinking about Securities Acts 1933 and 34 is whether the misstatement was in a registration statement or not. And so, in order to apply Section 11, it has to be a material misstatement contained in a prospectus or the audited financial statements contained in a registration statement. It cannot be from ongoing trading of securities. And so, but the reverse is not true. So if we're looking at applying the 1934 Act, you could potentially try and bring a case under the 1934 Act for, say, fraud, for a fraud that occurred with the registration statement. However, you wouldn't want to, because in bringing the case under the 34 Act, you would have to prove four things, and then under Section 11, you'd only need to prove two things. So you'd never want to. So it's never going to be the case that you're going to, if uh, you're never going to want to try and demonstrate that the 34 Act applies to a registration statement. You'd be much better off just going ahead and using Section 11. However, for the purposes of this uh, particular problem, if all of the criteria are met, go ahead and select yes as being an okay way to go about bringing a suit. So let's look and again see which ones of these apply. So the 1934 Act, we're going to have to prove either mystery or mystery, and we can't do that. We don't have reliance, and uh, we don't have recklessness or scienter. So the Securities Act of 1934 is not going to be applicable here. Under Section 11, all we have to prove is injury, which it looks like there is injury, and materiality. And that also looks like it's there. So the 1933 Act applies provided we're talking about a registration statement, and in this case, we are. So on an exam, look for those things. Look to make sure if you see this that we're talking about a material misstatement, whether the individual, the CPA, was aware of the fact or they were not aware of the fact, whether the audited financial statements are part of ongoing financial reporting requirements or a registration statement, whether the individual relied on the information or not, And ultimately, obviously, did they lose some money as a result of this? So, this is just a summary of all of the things related to both common law liability as well as Securities Act liability that we discussed. What are the burdens of proof? Who's the burden of proof on? Is it the client? Is it third party? Who's it on? What are the defenses that are available? And so this is just a good summary of everything that we've discussed from learning objective 1 all the way through here, learning objective 5. And that is it.